Can police arrest you, take you to trial, you be found not guilty by a jury, and then cops turn around and arrest you again and try you twice? Is there a double jeopardy loophole being used by cops and prosecutors? As a former prosecutor, now turned people's lawyer, I have witnessed this activity. I have seen how intricately both police and prosecutors can work together to take what seems like an open and shut case and a very simple Fifth Amendment right that each and every one of us has under the United States Constitution and transform it into a tool that creates injustice. In fact, right now, there are people sitting in state or federal prisons serving prison sentences for crimes they were exonerated for in another court based on the same crime. And they're trying to reach out to the United States Supreme Court begging for justice. So how does this happen? The Fifth Amendment to the United States Constitution provides, and I quote, that no person shall be subject to the same offense to be twice put in jeopardy of life or limb. And the United States Supreme Court has ruled, and I quote, a verdict of acquittal is final and cannot be reviewed on error or otherwise without putting a defendant twice in jeopardy and thereby violating the Constitution. The rule here might seem simple. If the government accuses you of doing something illegal, they only get one shot at trying to prove it. And whether you're acquitted or convicted, they only get one bite at the apple and they don't get to try twice. But is there a loophole? An actual exception to the Fifth Amendment here? Yes, there is. In fact, wait around till the end of this video and I'll explain how this double jeopardy loophole actually applies to President Trump and some of his active cases. In 2015, in the case of Gamble versus United States, Terrence Gamble was driving down a roadway in Alabama when he was pulled over by a police officer for an inoperative headlight. The officers approached Terrence's car, and as they did, they claimed they smelled the odor of marijuana coming from the car. They used that as a justification to search his car, and of course, what did they find? They found a loaded handgun and 2 baggies of marijuana. Because Terrence had previously been in trouble with the law, he was actually charged with a felony weapons charge and ultimately took a plea deal where he took a 10-year probation with 1 year in jail as a condition of the probation. Just when Terrence thought his nightmare was over, the feds started looking very close at Terrence, and now they wanted to look for a law that was the same as the state law, and they could use that now to justify arresting him again. Here's the kicker. Because of Terrence's prior plea in state court, which by the way, the feds could use against him in federal court, Terrence felt like he had no other choice but to take another plea deal in federal court. Here's what's crazy. Terrence ended up with another 3 years added to his sentence for the exact same crime. Imagine working out a plea deal on a state level case and to think your nightmare is over, only to find out the feds were waiting in the back corner, waiting for you to plea so that they could use your plea against you and turn around and sentence you all over again. Here's the problem. We all know that the United States Constitution was written, designed to stop hungry prosecutors looking to get a conviction at all costs after you have been found not guilty by a jury. But Mr. Gamble learned the hard way that there is a loophole to the Fifth Amendment, known as the dual sovereignty doctrine or the separate sovereigns exception. The Supreme Court established this loophole by fixating on which branch and arm of the government is trying to actually convict you in court. Simply put, the court said that there is federal government and there is a state government, and they are seen as separate sovereigns. As a result, they can try to throw the book at you for the same crime in different courtrooms. Unfortunately, that's exactly what happened to Terrence Gamble. Because both state and federal courts have separate sovereign powers, now those prosecutors can actually collude and work together in order to look to convict you twice for the same crime. What's worse, what if you're acquitted of a case in state court, and then after a jury's already found you not guilty, the feds get a phone call from the state prosecutor who's angry about the not guilty verdict, and now the feds can start putting a microscope on that same person who was found not guilty to now be hauled into federal court. And as Terrence Gamble learned, even if you're convicted in state court, the feds could turn around and decide to charge you with the same crime in federal court, and you could receive a much longer sentence. So how did this happen? The United States Supreme Court first set up this separate sovereigns standard here, this exception, back before the federal criminal code exploded with punishments for every crime imaginable, including crimes that now pretty much track every state criminal code statute. Once the federal criminal code exploded to over 4,500 crimes on the books, now here's the reality. Almost any state crime that you could be charged with, there will be an accompanying federal crime that could go along with it, which means you could be double charged for almost any crime. Some people say, hey, look, who cares? Maybe someone does deserve to be double punished in an example, and I'll show you some illustrations of where this took place, but I want you to understand what this type of precedent creates. Number one, it becomes a tool in the hand of a conviction-hungry prosecutor who maybe they're disappointed or hurt that they lost the first time around in front of a jury. They can turn around and work with their federal or state counterpart and charge the same person with the same crime and try them all over again. We'll be right back with more about this double jeopardy loophole. But first, a word from our sponsor, BetterHelp. Do you ever start playing the game of what ifs that begin to cloud your brain whenever problems arise? I have to admit, I've suffered from anxiety for most of my life. It's tough staying present when you're constantly picking apart your thoughts. As I grew in my entrepreneurial career, I realized I must take action to stop those spiraling thoughts and focus on what I can do to better myself. Therapy has been key for me. It's helped me to be able to gain an unbiased opinion from someone to help me organize my thoughts so that I can make sure and determine what's real and what's made up because of my anxiety and fear. Whether you're like me and suffer from anxiety, or maybe you have been facing grief or loss, you deserve the clarity and peace that therapy can bring. If you think that therapy is the next step for you, BetterHelp is a great option and I highly recommend it. It's convenient, accessible, affordable, and entirely online or by phone, whichever is most comfortable for you. A brief survey can have you matched with a therapist who has years of experience helping people with struggles just like you and I, and usually within 48 hours. Visit betterhelp.com/HamptonLaw today to get your special 10% off your first month. That's betterhelp.com/HAMPTONLAW. Here's how it would play out. Imagine a detective just knows you did something wrong. And so they decide to establish a probable cause warrant to have you arrested. You know that you're innocent and you've done nothing wrong. So you fight your case all the way up to a jury trial. Your attorney gets up there, fights valiantly. The jury believes you because you are innocent and now you are found not guilty. Now, imagine the same state prosecutor who tried to put you in prison and now they've lost. They pick up their phone, they call the federal prosecutor right across the street, and they start talking to them about your case. And they believe that you were guilty, no matter what the jury said. As the state and federal prosecutor keep talking, they very quickly realize that there is a federal crime that matches the same state crime that you were found not guilty of. So now, within a mere few days after that phone call, you learn that the feds have launched a criminal investigation into you for which you now have a new warrant and you have to pay a new bond. And ultimately, you'll have to pay an attorney again to defend yourself to prove you're innocent for the exact same crime you've been exonerated from. Now, some of you are saying, oh, come on, Jeff, that will never happen. Actually, state and federal prosecutors work together on cases all the time. For example, if someone is charged with both a gun charge and a drug charge arising out of the same offense, it's not uncommon to have a federal prosecutor evaluate the case and the state level prosecutor to also evaluate the case, knowing that, let's say it starts in state court, if the state court prosecutor ends up losing that case, the feds still have an opportunity to bring another charge against the same person for the same offense. In fact, there have been some examples where both state and federal prosecutors will coordinate together on higher profile cases, knowing that if they lose on the first round in state court, they have a second bite at the apple in federal court. To me, this feels a lot like a loophole to the Double Jeopardy clause that allows both prosecutors and police to exploit this. But that's certainly not what Justice Alito thinks. Justice Alito believes that, on the contrary, it's not an exception at all. Justice Alito wrote, and I quote, "An offense is defined by a law, and each law is defined by a sovereign. So where there are two sovereigns, there are two laws and two offenses. The people split the atom of sovereignty," whatever that means, "between states and the federal government, giving each the power to punish crimes. In short," he said this, "a crime against two sovereigns constitutes two offenses because each sovereign has an interest to vindicate." Now, how does this all apply? Believe it or not, it could apply to President Trump and his former associates. For example, Paul Manafort and Michael Cohen were initially convicted of federal crimes for which President Trump, while he was still president, had the power to pardon them from in federal court. However, they both could have been charged and almost were charged in state court by District Attorney Alvin Bragg. Think about how this could work. Trump did have the power to pardon both Manafort and Cohen for the federal crimes, but he did not have the power to pardon them from state crimes. Why? Because federal pardons issued by the president only apply to federal crimes. Presidents cannot pardon for state or local crimes. Pardons for state crimes are handled by governors or the pardon board. This is just one example of how this loophole can be used for political purposes to punish the other side or to exact retribution on someone. In fact, the most famous example of this loophole being used was in the Rodney King case. After the officers involved in Rodney King's beating were actually convicted in state court, the feds decided to turn around and also bring federal charges against them. Federal civil rights violations led to additional federal consequences for those officers. Now, does this policy seem to work for everyone, or is anyone at all concerned about this? Technically, even the Justice Department recognized how this could be a tool for retribution, so they created a standing policy that their federal prosecutors would not follow up with a federal charge after a state-level conviction. But that federal policy does not stop state-level prosecutors from following up after a federal conviction and recharging the same person for the same crime. And what if the feds choose not to follow their own policy? Well, in that situation, there's not a thing you can do about it. You can't go into court and argue that they're not following their policy because a policy is not a law. In other words, the policy is not worth the ink written on the paper. This crazy double jeopardy loophole is on shaky ground with everybody except the U.S. Supreme Court. Both liberals and conservatives, judges and scholars hate it and they think it's wrong. But apparently it's here to stay. That's a shame for criminal justice reform because we'll continue to see people like Gamble end up taking a plea deal only to turn around and be double punished for the same crime. Speaking of loopholes, do the police have another loophole when it comes to the Fifth Amendment and your right to remain silent? Check out this next video where I break down how cops have a Fifth Amendment loophole where they may be able to use your silence against you. See you over there.